A very warm welcome to everyone attending today's session. Today we have with us once again Senior Advocate Mr. Satyajeet Desai. He's going to talk to us about his journey in law. This is part of our series of In Conversation. Welcome, sir. It is our honor and privilege to have you, sir.
Thank you for welcoming me to your organization.
Sir, today we're going to ask you a lot of questions about your journey in a question and answer format. And I would like to start with the first question about your background. You come from an eminent family of jurists and lawyers. Your grandfather, the retired Justice S.T Desai, was also a barrister from Lincoln's Inn, and he was a judge at the Bombay High Court and later the first Chief Justice of Gujarat High Court. Post his retirement, he practiced as a senior counsel in Supreme Court. Before him, your great-grandfather, Mr. S.T Desai, too, was an eminent lawyer in Mumbai. So, with this lineage, who or what inspired you to take up the profession as a lawyer? Was it by design or was it simply by default?
You see, as you said, I come from a long line of lawyers. Growing up, I was always surrounded by an academic atmosphere in the house. There were lots of books, in fact, around the house, dealing with law, dealing with general subjects, fiction, non-fiction, anything under the sun was available in our house. So it was a house full of books and people talking about various things. So basically, growing up, I was always surrounded by the atmosphere of law. And as you rightly said, since my ancestors were lawyers, I thought about nothing else. I always wanted to be a lawyer and I always wanted to be in the profession. So I would say that I have really followed that time-honored family tradition in becoming a lawyer.
What was it like growing up with a grandfather who studied as a barrister in Lincoln's Inn the same time as Gandhiji and other stalwarts? During that particular period, it was very difficult for Indians to succeed in law and to become barristers because of implied racial prejudice. It was difficult to travel, to live, to succeed in Britain. Would you like to share some of those stories if you can recollect?
As you said, you see, I am proud really to say that amongst the profession, my grandfather was very highly thought of. After having completed his law studies, in fact, from the Government Law College, Bombay, he went to England to become a barrister. After returning to India, he joined the chambers of an eminent advocate in 1927. That was, of course, the time of British rule in India. Things were difficult, times were difficult. Indians came second because we were ruled by the British. Now, if I quote an instance here, he was asked by his senior to mention a matter for an adjournment which was absolutely necessary. Of course, the judge was British and there was no love lost between that judge for Indian lawyers, An English lawyer was mentioning a matter and he was granted the time that he wanted. After that, when my grandfather mentioned the matter for a short adjournment, he was grilled like anything by the judge and was given very less time, which would have been less to complete whatever the senior wanted to. In fact, that is, in fact, the time when a thought entered my grandfather's mind as he recounted to me later, that if at all I am made a judge of the High Court or any other court, I will always be kind to juniors. Now, this actually happened. He was appointed as a judge of the Bombay High Court on 8th of October 1952. His court was always throughout his tenure known as a junior's court. And he, in fact, fulfilled a promise that he made to himself. In fact, this fact is mentioned in the book that was brought out by the Bombay High Court on completion of 125 years, that S.T Desai was always known as a junior's judge.
That's very interesting. Would you like to share some of the snippets of any of the judgments of your grandfather, if you recollect?
Uh, I'll refer to one judgment that he delivered as one of the first judgments that he delivered as the first Chief Justice of the Gujarat High Court. That was the judgment of Anand municipality after the States Reorganization Act, after Gujarat split from Maharashtra. The question was as to how binding were the judgments of the Bombay High Court so far as Gujarat was concerned. The full bench, which was headed by him, held that those judgments which were delivered before 1st of May 1960 were indeed binding upon the Gujarat High Court. In fact, probably the words that he used were, "We look upon that pedigree with filial gratitude," if I remember the words correctly. And that judgment is still cited not only here but throughout the country, wherever a case of states reorganization comes in, and about applicability of judgments of the parent state, so to say. So that was a very important judgment that was delivered by the Gujarat High Court, of course, speaking through Justice S.T Desai.
Okay. In your case, sir, you've been practicing for more than 33 years. Can you describe your journey in law, how you started out? What are the challenges you face? Although you're from an eminent family, there are different sets of expectation and challenges which you would have faced, which any other junior would not have faced.
Yes, you are right, so to say. In fact, as I told you earlier, I always wanted to be a lawyer, worked towards that. One interesting thing that I would like to say here is, you see, lawyers deal with language, logic, etc. So I always wanted to, study arts with English as a major. But I don't know what happened. Somehow or the other, because other friends were going in for BCom degrees, I went in for a BCom degree. I admit here that I used BCom only as a stepping stone to get into the profession of law. Even if today I'm given a chance, I would probably do BA with English. That is how much I love the language and the study of logic that is available in that stream, I would say. Once I entered the profession, or rather just before I entered the profession, I interned with a stalwart of the Gujarat High Court Bar, Mr. S.N. Shelat, who is our former Advocate General. I interned with him for about a year and a half, and thereafter worked with him for about 3.5 years. He had a large institutional practice. So I also got a chance to deal with some institutional matters in his office. Thereafter, I joined the offices of another stalwart of the bar, Mr. K.S. Nanavati. He had a corporate practice. And assisting him, or even independently, I got a chance to do quite a few high-stake matters also. The thing that I, in fact, learned from my seniors was never let anything, faze you. Absolutely. You must remain unfazed. Whatever the stakes of the matter, whatever is involved in the matter, you prepare properly, put up your submissions before the judge, and don't get unfazed by anything that is asked to you. So you have to be really thinking on your feet, I became independent on, in fact, the 1st of August 1994. And obviously, after you leave a senior's office, being a junior in the profession does work towards a disadvantage, I would say, because you have to work harder in order to establish yourself. Even though you may be from a family of lawyers, from the profession, In fact, the responsibility is much more harder on you. That is a push. But after that, you have to prove yourself, because that connection is going to take you this far and maybe no further if you don't work towards it. So, probably a person with, say, family connections has to work much more harder, I would say. In fact, you are judged differently because you have a very large pair of shoes to fill, I would say. I would end with saying that.
Can you tell us any other guidance which your seniors gave you, which has held you in good stead over the years?
I have said this before also. What I, in fact, learned from my seniors, from observing them, was one, of course, be very well prepared. Secondly, was that read the brief thoroughly. Always be prepared for any questions that may be asked to you by the court. Be courteous to the court while making submissions. Be courteous to your opponent also. Don't lose your cool. Don't get angry if you are caught on the wrong foot. Uh, you can always get through by thinking it out logically and by putting up your submissions in a proper manner. And of course, for that, you have to burn the midnight oil, as they say, or get up early in the morning and read. Always be well prepared. And of course, I'll add one more thing here. Uh, Law deals not only with logic and interpretation, but with language also. So your language must be proper. I'll say that.
So, a good habit of reading is very essential, also, which promotes your practice.
Yes, absolutely.
So, in all these years, what, in your opinion, have been the changes in advocacy, in the way it has been practiced? You've seen through two, three generations.
Hmm.
There has been a sea change in the way advocacy has been practiced. Can you
Yeah.
highlight over a period of time what were these changes that you have observed?
Now, if I say this, you see, let's look at it first from the point of view of preparation of a brief. See, once a client comes to you, you have a conference, you listen to your client properly. After the client goes away, your work starts. So, first thing is legal research. In the earlier days, in fact, right up to the mid 90s, I would say, how would lawyers do legal research? Sift through, commentaries, sift through digests on law to find out precedents and all that. Now, what happens is those are still available, but with the advent of the internet and with online offline databases, things have become slightly easier. So that is a big change that has come about. Legal research has become faster, slightly more easier. Now, if again I go to the technical aspect of the law, earlier, say, suppose a brief was to be dictated, you dictate it to the stenographer, he types it up. It used to be done on typewriters, all of us know. And many of this generation probably may not have seen typewriters. If any change was required, whole thing would have to be redone. Again, technology has come to our aid here. With computers coming in, it's so easy to make changes. Why? Because you can store things. You couldn't store things on a typewriter. So that is another change that has come about. So in both ways, there are a lot of changes that have taken place, which have in fact benefited the profession, benefited lawyers, made things slightly more easier.
So these are the logistic ways of in which advocacy has been changing over a period of time. Are there any
Yes.
other ways you would like to point out in the approaches, uh, in the manner in which matters are dealt with, or anything else?
Yeah,
Any
I would say that you see, over a period of time, you've all seen that the number of matters in courts have gone up. As a result of that, what has happened? Uh, Judges are pressed for time, courts are pressed for time. So earlier, you would see that even the judgments were longer, save and except a few judgments now, which are quite long. You will find that judgments are not that long. Why was this? Not probably because of the issues, but lawyers also had probably more time to develop their arguments. Matters would go on for a long time. Now, as I said, since judges are pressed for time, what lawyers have to really learn is put things in perspective, be as brief as possible, try not to repeat oneself. These are things that are really part of advocacy, I would say, these days. Put your point across, be brief, and quote your precedents. That's all. These changes have happened and they are probably here to stay. So, longer arguments versus slightly truncated arguments with the aid of technology, of course.
So you come from a long lineage of 5 to 6 generations as jurists and eminent lawyers.
Hmm.
Who, in your opinion, have been the stalwarts or persons who have shaped the Indian judiciary or the legal justice system in India?
Oh, that's a very good question. See, if I would give 3 or 4 names here, I would say. Uh, First name I would like to say is, of course, Great Justice M.C. Chagla. Then Justice H.R. Khanna amongst judges. There are many, but I would give these 2 names so far as judges are concerned. So far as lawyers are concerned, we have had Mr. M.C. Setalwad, the great Mr. Sirwai, Mr. Palkiwala. Look at their contribution to the law through their advocacy, through their writings. All that has influenced legal thinking so much. And these people have been really great contributors to the legal system, I would say, and law in general as a whole.
Any judgments of theirs or any mannerisms of theirs which you think you could have adopted or which can be adopted by the current generation?
I really can't speak of mannerisms because all of them were probably before my time. But I do remember something that Mr. Sirvai used to do. Though a slight man, he was so very assertive while arguing, I am told. And that carried forward to his private conversations with his lawyer friends also. One mannerism that he had was, and I probably think he might be doing that in court for all we know. Somebody from his family can probably assert to this. If he's sitting on a chair while making a point, he would bang his palm on the armrest of the chair. He has in fact done so at our place when he used to come to meet my granddad. They were friends. He would, to assert a point, he would bang his palm on the armrest.
Okay.
That's a mannerism, of course, that I'm speaking about. Uh, Assertiveness amongst lawyers is, of course, well known because they put forward their points in court. But then again, all that also depends upon the receptiveness of the judge. Some judges might feel more offended if you try to be more than assertive.
Sure.
You have to do it in a very proper manner.
Why your choice of both of these judges? There's a long list of judges who have made landmark, but was there um something special about both of them? Was it their writing? Was it their clear thinking? What was it that was unique about the two you have named?
Writing and clear thinking, both, I would say. And if you look at Justice Chagla's career, see, in many cases you will see a person is a lawyer, then he becomes a judge, perchance he becomes a chief justice. But so far as Justice Chagla is concerned, that was in fact not the end of his career. That was in fact the beginning of his career. Look at how he progressed later. He became ambassador of India to a country. He did a lot of things. Look at his legal writing. I would urge students to read his autobiography and you will know so much about the man. It's not only the law that he was concerned with, that was probably the first step. So that is why Justice Chagla. If You look at Justice Khanna, I would say look at his judgment in the fundamental rights case. Look at what he did in ADM Jabalpur. That should speak volumes about the contribution of the man as a
Absolutely.
judge to the profession. Basic
Absolutely.
structure of the constitution. Look at how he did it. And
Okay.
what more could there be?
So you come from a line of lawyers who have written various books and treatises, right from the criminal law journal to writing books on trust, equity, limitation, easement, government tenders,
Hmm.
Contract and Sale of Goods Act. Your grandfather, retired Justice S.T Desai, was the editor on the 12th edition of Mulla's Hindu Succession Act,
Hmm.
as well as the treatise on the partnership written by his father. You, sir, are the current revising editor of the 21st edition of Mulla's Hindu Succession Act. In addition, you have a blog in which you share your thoughts and opinions on legal issues. So, in all this, what, in your opinion, is the importance of good reading, writing, continuous learning in the career of a lawyer? The importance of being a perennial student of law.
Well, this I would say is true of every profession. You must keep on updating yourself. But so far as law is concerned, everyone is a perennial student. In fact, I have heard a late senior advocate of our Gujarat High Court saying at the age of 78 or so that I am a student of law. I mean, you learn every day. So far as legal writing is concerned, I would say it's very, very important to me. I'm passionate about it. And why? Lawyers, tools of trade, what are they? Words. How much more can you contribute to the profession if you write on issues on the profession? Say, if you write on a subject, you are giving back something to the profession. But while doing that, while writing, say, a general article on a particular subject is fine. But say, if you are writing on a law, on an aspect of law, or a commentary on a particular act, I would say, have to be very careful. And why is this? Whatever you write must be middle of the line in the sense that it cannot reflect your personal views. You have to try and interpret the law in such a manner and write about it in such a manner that it is acceptable to whomsoever writes it and cites it. Courts must also, accept your view. And when would they accept your view? It can't go to the far right or the far left. It has to be written in such a manner that you are trying to reflect what the legislature probably thought while putting particular words in the section. So that's why it's very important to write in a particular manner and not go off on a tangent. You spoke about reading. See, if I talk about reading skills, that is also very important to a lawyer because a lawyer must have the ability to absorb and read things quickly and then go ahead and write, go ahead and make submissions in court. Now, this would assume significance even while preparing a brief for the court. In fact, I read something very unusual and funny somewhere that papers that are put up before the court, the files are so thick at times, but why are they called a brief? Somebody said. My answer to that was, it is still a brief. Why? Because courts depend upon the submissions and arguments of lawyers. That is something more that is added to what we call a brief. So that also assumes importance here.
So, what, in your opinion, were your skill set which set you in good stead? And correspondingly, what are the skill sets a student should possess or develop during the college days for becoming a good lawyer? Would you say to that extent that a personal attitude, ambition, hard work? mentoring opportunities help?
Yes,
Which are the
hard work, mentoring opportunities, everything helps. But of course, in the end, it all depends upon the student. And if you are serious about the profession of law, one thing that you have to inculcate is the habit of reading and absorbing things. Read up on the law, try and interpret things, put questions to even your professors so that they also know that this person is serious about things. When you put questions, you get answers. Another important thing is, as I said earlier, language is very important in law. To have good language, it's not only important to read upon law, but I have always stressed upon general reading. You must have the habit of vast and general reading. And when anybody has asked me about reading in the past, I have said in a lighter way, but I am very serious about this when I say it. So far as I am concerned, so far as general reading is concerned, I read anything from Archie to Aurobindo and Zorro to Zarathustra. Anything that comes to my hand, I read because it adds to my knowledge. It's going to help me someday or the other. So students have to inculcate the habit of vast reading.
which were the three skill sets which held you in good stead and which still do?
I would put it this way. One is dedication towards whatever you are doing. Two, research. Mentoring helps only to a certain extent, you see, because your mentor will probably guide you in a particular way. But after that, you are on your own. So, uh, drafting skills have helped a lot because you see, when the judge reads a matter at home, he must find that, oh, this point has been taken. We have heard it so often in court, Mr. So and so, have you taken this up in the brief? If it's not there, probably the lawyer would have to say amend his petition. Or maybe if the judge is not convinced with what he has written and he doesn't want to give an inch to the lawyer, he will probably just dismiss the matter.
Hmm.
So,
Hmm.
uh, being, I mean, a brief has to be properly written.
Sure.
Research everything, research the law and write your brief. Research helps, language helps.
Who are your ideals in college, your professors, your co-students, maybe family members, and how did they shape your thinking?
Of course, so far as I am concerned, my ideal and my hero has always been my grandfather, Justice S.T Desai. That is one. Uh, Next is my senior who is still in practice, Mr. S.N. Shillat. I mentioned him a while back. He is in his mid 80s now, still in practice. I don't call him my senior, I call him my guru. And why? If you're discussing something with him, some issue, he'll say, oh, why don't you look up so and so Supreme Court page so and so? He's so ready with things, you know, so much research oriented, so ready with things. That is something that I have tried to inculcate. So far as professors are concerned, when we were studying, of course, we had regular professors also, the regular faculty. Some of them were so good. I remember what they have taught us even today. But I want to talk about a person who has not taught me, but what impact that person has had on me. A few
Okay.
years back, our publishers had a function in New Delhi where all authors got together, law authors got together. It was a gathering.
Mm-hmm.
I went up to this old venerable author who was sitting there. I
Mm-hmm.
introduced myself to him and I said that, sir, I am your student. Whenever I have to go back to the basics about certain thing, even while preparing a brief, I've always gone back to what you have written in your compendium or your book on commercial laws. Uh, he blessed me. What was his name? The late Dr. Avtar Singh. The way he has written that book on commercial laws, it's, I would say, it's a compendium commentary for students on commercial laws. Of course, it is. I am told that it has now been renamed. But when you want to go back to the basics, the very bare minimum, that is the book to go to. That has had a very, very big impact on me. I'll add to this. You see, while writing, your language also, you might have good language. And I've also fallen victim to this while writing. I try and use fancy words because I know them. But as far as possible, what I try and do is while writing, I try and use simple words. Why? Because everybody is going to read them. I don't want people to go and pick up a dictionary every paragraph. What is this author saying? Let me find out the meaning of this word. No, that will not work. Simple, proper language always works. So these law authors who have written for students, and even some lawyers, some other jurists who have written on law, they have had an impact on me. Why? Because not only because of their interpretative skills in law, but because of the way they have put it up in there. So this has had a great impact, I would say.
So very simple, lucid language makes a
Simple,
lot of
lucid language always helps.
you have dealt with a number of matters of various kinds in many courts before many judges. Can you talk about some of them which have shaped you, which have challenged you, and which have left a lasting impression on you? It may be uh, a chat between the bar and the bench. It
Hmm.
can be anything which has changed the way you have practiced.
Ah, a very interesting question that you put. See, as I told you, over the number of years, 32, 33 to be precise, dealt with a lot of matters, some of them routine, some of them very challenging in their own way. But since you have asked me this question, I would like to quote two things here that are really close to my heart as to, and why is this? How the profession of law can help people. I'm on that rather than a court matter. You hear
Okay.
lawyers talking about their court matters, but this is probably, I believe, something unusual. And this has shaped me, I would say. These two things. Both are relatable to me. In
Okay.
one instance, somebody came to me with another gentleman saying that, sir, he has a problem. He can explain it to you. Please try and help him. Now, what was the issue? That man had migrated to Gujarat from West Bengal. His sister was living here. Widowed sister was living here and working somewhere. He and his sister were living in a house. Now, they had some problems with the cooking gas company. They were not getting a connection, or there were some huge issues. They were unable to cook. I looked at whatever he had, whatever little correspondence that he had made. And then I thought about something. I helped him out. And after a few days, he gave me a phone call saying that, sir, my work is done. Thank you so much. But the matter did not end there. I was having a talk with a friend about a month after this incident. And that man who had that problem with the gas connection, he just came towards us and he just prostrated himself towards me. I said, what are you doing? Don't do this. He got up. The other man who also knew him asked him, what happened? So this man said in Hindi, साहब आज मेरे घर में साहब की वजह से खाना पक रहा है. That is one instance, one small instance where a little bit of law can help someone. The other instance that I would quote is I would use the words flabbergasted when I received a letter from Uttar Pradesh in very chaste old style Hindi written by some litigant anonymously. And he said that, sir, we had a property dispute in the family. I succeeded. My lawyer told me that it is because what you have written in your book, Mulla's Hindu Law, that has helped me succeed. I mean, we can't do anything for you. But the only thing that I can do is bless you and your family. This impacted me to such an extent. Every time that I look at that letter or I read it, I am more humbled, This is how law can really help. Court matters, yes, but this also is part of law. That
Yes.
that has helped to humble me, I would say.
So you've been part of the Law Commission workshops in which there were once again attempts to move towards a common or a uniform civil code. But ultimately, changes were made only to the personal laws. What are your thoughts on it?
Well, for one, that's a very sensitive topic, but I'll try and elaborate upon this. You see, at various times, attempts have been made to bring in a common civil code, and those attempts have not borne fruit. And why is this? If you see, the right to religion is a fundamental right, that is a given. Whereas, if you look at the article that mentions Article 44, which mentions the common civil code, that is a directive principle. There have been opinions expressed, and in fact, I have also done so even recently in an article which I'll talk about presently. See, if you talk about bringing in a common civil code, which is right now a directive principle, then you are going directly against a fundamental right which is given. And why is that? Because it is not only the right to religion that is involved here. Our constitution recognizes not only right to religion, but therefore, by extension, the personal laws that have been based upon religion. So if you bring in a common civil code, what you are doing away with is thousands of years of a system which has been in place, which is good. Yes, maybe changes are required, and changes have been made. In fact, the last law commission, what did they do? In fact, they found, and as you said, I was asked to give an opinion on impact of Supreme Court judgments on a common civil code. I gave my opinion. After the report of the Law Commission, I even criticized it on a site. I am not going into that criticism. But why did the Law Commission think that this judgment had the effect of doing away with, say, so far as Hindu law is concerned, co-partnery or HUF? They were referring to the judgment of Uttam versus Sobhag Singh under old Section 6 of the Hindu Succession Act. Now, in fact, while dealing with the latest judgment, the full bench judgment, which I talked to you about in another earlier webinar,
Yes.
the Supreme Court has also dealt with the old Section 6, and what has it said? It said that if a co-parsoner dies, it does not mean that the co-parsonery comes to an end. It is in fact on the basis of that judgment that the Law Commission probably wanted to hold that because of this judgment, now that co-parsonery is dead, we can go ahead and recommend a common civil code. Ultimately, they went and recommended changes to personal laws. Why is that? And now we have seen what the Supreme Court has done even in the last judgment. So thereby, by necessary implication, the judgment in Uttam versus Sobhag Singh has in fact been impliedly overruled. So bringing in a common civil code is going to be, I would say, it's not impossible. It can be done. But as it has been interpreted by the Supreme Court somewhere in 1995 or 96 in a judgment is that it is a giving power. This is not something that you have to do. It's a giving power. So that is the impact that is there.
So many first generation lawyers believe that they cannot break the glass ceiling, whether on account of religion or family connection, in the profession.
By the fact that they are facing people who probably have some background in the profession. My advice to them would be work hard, do your work properly, research properly. If the judge is not going to depend upon the lineage of a person to decide a matter, he is going to depend upon what is written, what is the law. And if you put forward your case properly, then appropriate results are definitely going to follow. To prop that up especially for young lawyers, I'll quote the example of what was the beginning of the Bhagavad Gita. What did Krishna say to Arjun at the beginning? Karmanye vadikaraste mafaleshu kadachana. You do your work. Don't look at the results, right? So that is something that I would tell them. And we must all remember, forget the other cohorts that they had. But the Pandavas were 5, Kauravas were 100. Who won? Work hard, and if your case is good, if your preparation is good, and if the law is on your side, your client is going to succeed, and by extension, you are going to get that success and add to what you are doing.
So, just as corporates have CSR or the corporate social responsibility, I understand that you, as a professional, have pursued certain responsibilities at an individual level, like making awareness of making a will in this pandemic. Can you tell us more about this initiative of yours?
Yes, I have taken up the initiative, but I cannot take complete credit for that. I am just a torchbearer, I would say. I have started telling people, talking to people about wills on various webinars, and as to why wills are important, how wills can be made, how does making a will help you, and all that. But the real credit for that idea has to go to two individuals who are very, very dear to me. They are lawyers. They are my daughters. Both of them, they came up with this idea saying that you are known in the field of personal laws. Why don't you extend that by going into the field of wills and in fact try and explain to people, especially during the pandemic, as to what is the importance of making a will. So that individual social responsibility, as you put it, as compared to CSR, is in fact the brainchild of both my daughters who are in practice but independent of me. So I must give them all the credit for this.
Sure, that's true. And I think we should also, in each of our personal capacities as lawyers, should also pursue such individual social initiatives using the tools of what we have learned and our experience.
Yes, yes, because ultimately you are helping people.
So you're also the visiting faculty of a lot of legal institutions on the subject of family law and Hindi law in particular. What do you think is the importance of teaching and experience sharing by a lawyer? And also the importance of educational institutions, whether you call it schooling.
Uh, I'll take the second part of the question first. Uh,
Yes,
you see, whenever first teachers, so at least
yes,
up to the age of 3 and a half, the child is learning something at home.
yes.
After the child is put in school, there is institutional learning, various subjects as they go forward. And the child learns about interaction with others, learning various subjects and all that. So far as teaching in law is concerned, if I straight away jump to that, there are two kinds of faculties or professors who are available for this subject. One are, of course, the regular faculty members, and the others are the guest faculty or the visiting faculty. As I have been told by several regular professors themselves, because I go for guest lectures, not regularly, but guest lectures when I'm invited. They say that we may teach them the whole theory, but when you teach the same subject, that is that X factor that is added to it. Why? Because you add your experiences by examples, by say live court cases or cases that have already happened. You try and explain to them as to what has happened. In fact, I'll quote something here. When I was teaching a particular class about say the Hindu Succession Act. After a couple of lectures, I just told them that next lecture I want you to pick up two judgments of the Supreme Court on this particular issue. In the next lecture, I just asked, have you looked at those two judgments? A couple of students answered that yes, they had. They were unprepared for what actually happened then. I just went and sat where students sit. And I told the student concerned, all right, please come to the front and explain to us as to what the judgment was and what was the impact of the judgment. Student was so flabbergasted, could not speak for about 30 seconds and then started explaining. Then they came to know that, oh, this man is trying to teach us in an interactive way. And they liked it so much that they started probably urging their other professors that why don't you pick up this method of teaching? So that is what I try to do. I try to involve students whenever I teach. I try to involve them
Mm-hmm.
in doing things, in understanding. Because if you look at the interactive method of teaching, what is it? It urges the student to read, to interpret, and then to speak out. That is ultimately what they are going to do if they become litigating lawyers.
Yes,
So this
yes.
helps.
So, in the current scenario, a lot of education has moved online or is being delivered in a hybrid manner, which is part classroom, part online. In your opinion, how will the teacher shape the minds of the students? Because this is a completely different methodology.
Oh yes, oh yes. One thing, of course, is, and we have all heard about what happens in classrooms these days, because this thing is new because of the pandemic, uh, the COVID-19 pandemic. First of all, of course, they have to have regular hours of teaching. That they must be having, that can be done. But here also, I would say, as I said earlier, in order to make it more effective, what really needs to be done is that people who teach, the professors and the teachers, must adopt an interactive method of teaching, because that is what will help. You can't hold the attention of a class for more than a certain point of time when you are teaching online, because that is a completely different experience. So you have to make it more interactive, more research oriented. That is the only way in which remote teaching, as I call it, can really help.
So, what would your advice be to professors, to law colleges? There are a lot of colleges now which are becoming deemed universities. Uh, the government has allowed certain colleges to change the methodology of teaching, and in some cases, additional curriculum subjects have been added to make learning a little interesting. What would be your advice to such colleges? What are the improvements you would like to suggest?
Again, as I said, I might sound as if I'm repeating myself, but interactive teaching is really going to help. That is
Yes,
one. But
yes,
one thing that I would really like to say is, and I have said this before also, you see, over the years, and especially since the last decade, what we have seen is that there is a lot of interest so far as taking up the study of law is concerned. Earlier, it was not that much. Whatever the reasons are, I will probably not go into that. But suddenly, like say some other fields, medical or chartered accountancy, law would not probably be a preferred choice for so many earlier, but these days you see how many students want to do law, get into the study of law, and maybe get into practice or on the corporate law side. So, interest has picked up like anything. As a result of that, what has happened is there is a proliferation of law colleges. I would like to say here that it's quality that matters, not quantity. Don't spread yourself thin. The more the number of colleges, probably the level is going to go a bit lower. That should not happen. In fact, like say American universities at the graduate level, if you see, the class size is quite large. That can happen here. Uh, Probably increase the intake rather than increasing the number of universities. Uh, have a stringent test. You already have the common law admission test. Have stringent tests to really find out as to who has the aptitude to get into the profession. That is how only people who are serious about things will get into the field of law. That is how you can control things. You cannot probably control numbers, but this is how you can control things, by trying to see to it that people who have an aptitude for it get into the profession. Don't increase the number of colleges. Don't keep on doing that. Otherwise, that's going to be like, one dab of butter on two slices of bread. You are spreading yourself thin. Should not happen. Instead, do things differently.
It's a very relevant point, sir. So, would you like to add any other snippets of, would you like to share any snippets of um, your life and any other advice to young budding lawyers who are listening into this webinar?
Uh, well, there's not much to say about the journey that I've had up to now, at least. Uh, I would say keep on reading, keep on working, keep on doing research. And sorry if I sound to be repeating myself, but please inculcate the habit of reading other things other than law, that is going to help you so much. If I can quote an instance here, um, and of course this is relatable to a court hearing and how reading helps. I was appearing against a lawyer friend, a close friend of mine, in a matter. He was for the petitioner, I was for the respondent. In uh, his matter was dismissed by the court after my submissions. About 6 months down the line, similar matter, absolutely similar matter, only the parties were different. Lawyers were the same, but our roles were reversed. I was for the petitioner. After I finished my arguments, my friend got up, made his submission, and then pointed out that earlier order to the court saying that, sir, similar circumstances, our roles are reversed. And he gave that order to the judge. The judge smiled and said, Mr. Desai, sit down, you can't win them all. I said, now I quote something here. I said, similar thing happened to Mr. Abraham Lincoln when he was in practice, but it happened to him on the same day. In the morning session, he was appearing for the defendant and he succeeded. In the afternoon session, he was appearing for the plaintiff in a similar matter. The judge told him, Mr. Lincoln, this is the case, therefore you must fail. And Lincoln's answer is a classic. It's a lawyer's answer, I would say. He told the judge, Your Honor, I know that this morning I was wrong. So reading helps. That is what I mean to say. Reading in any form helps. Reading any subject helps. It's going to help you like anything, because it's not just threadbare discussion about law in courts. There are asides also. When you quote something, it piques the interest of the judge, and he might hold for you if he likes what you say. And that can only happen when you have read something extra, which you can relate to the matter on hand.
So, there are some questions for you.
Sure.
Um, so, the first question is, how do you manage your time between writing articles, your professional work, and preparing for matters? Now, I am aware, sir, that you have a very disciplined life. You wake up early, you deal with your matters at a particular time. You like take a break from your work and do other things. So, in light of that, how would you like to talk to us about it?
Oh, sure. Interesting question. I would say, just in order to see that I get at least a clear 3 hours, 2.5 to 3 hours in which to, read and then write on the subject. And then, of course, I move on to whatever court work that I have. In the evening session, of course, dealing with, say, lawyers who come to me to brief me as a counsel, or other clients, their clients. I also do a lot of opinion work on Hindu law, Hindu succession more particularly. All that happens, of course, over the weekend. Opinion work is reserved for the weekend. Now, so far as today's situation is concerned, to write. So I spend more time writing right now. So it's split in this particular manner. When court is in session, as I said, 2 to 3 hours in the morning and then court work.
Sir, another question is, would it be prudent for people in the legal profession to have exposure to legal concepts by a non-advocate?
Oh, very interesting question. Well, I'll answer this by saying that would you take legal advice from a doctor? No. Non-legal person giving advice is not done. You must always go to a lawyer. Why? I'll quote the example of a doctor here. See, suppose you have a headache. You take an aspirin for that. Maybe 1 day, 2 days. But if that headache keeps on happening, third day you will consult your doctor. You have to go to a doctor. So legal advice only from a lawyer. I'll add to this, and this is again very close to my heart. Somebody showed me a will which had already been prepared. I found that the will was all right. It required some small changes, but while doing so, when I looked at the first page, I was surprised. The will was on stamp paper. I asked, why is this on stamp paper? Who has prepared the will? He said, and with all due respect to the profession, I have a lot of chartered accountants. I'm in the family and I have them as friends. I was told that it was prepared by a chartered accountant. I said, you should have got it prepared from a lawyer. How does this add to the sanctity of the will? Because it's not required to be on stamp paper. See, you've just contributed 100 rupees to the government without anything, not being necessary. So that's why take advice from where it should be taken and from
Perfectly said.
whom it should be taken.
Perfectly said, sir. One more question is, any book that you would suggest for us to improve our language in the court practice?
I would say read any book. I would lay more stress on British authors because English is, after all, the language of the British. American authors, fine enough. Okay, they are good. Some of them are great. But if you want to improve your language, read British authors. While reading language and also reading on the law, please read all the works of Lord Denning, I will suggest. Read all his books. It's fantastic language, superb books that he has written. And that will give you a complete conspectus about what the law is. And why do I say Lord Denning? Because we were ruled by the British for such a long time, and our legal system is based upon their legal system. So you will find so many similarities when you read his works. So that will help you in language, in law, and improving your vocabulary to quite a large extent. Not only improving your vocabulary, but improving your legal vocabulary.
Absolutely, sir.
I am very pleased, in fact, to have been invited for this session. And I hope whatever I have said, whatever little that I have been able to contribute, helps people, helps my younger friends in the profession. So thank you, all of you.